Okay, good afternoon, and thank you for joining us. I'm Rebecca Pezzutti, the Legal Practice Director at IRiQ Law, and with me I have my colleague and co-presenter Terrianne Redman. Terrianne is a highly accomplished HR and IR consultant and is well placed to speak on this topic as somebody who supports our clients with particularly complex and sensitive investigations. Let me start by acknowledging and paying respects to the traditional owners of the lands on which we meet. For us here in Brisbane, Meanjin, it is the Yagara and Turrbal people. You're welcome to ask questions as we go through the discussion today. You can do that by raising your hand or using the Q&A or the chat function in Teams. Terrianne and I will moderate the Q&A and chat functions to make sure that we address any questions that come up as we go. And of course, because we are lawyers, today's webinar comes with a general disclaimer that this information is provided as general information and not legal advice. Of course, if you have any workplace or specific concerns within your organisation or that are relevant to you, we're here to help and we can provide legal advice, so reach out via one of our channels. In terms of today's agenda, this session is built around providing practical guidance that you can implement in your workplace. A recurring theme is that effective complaints management isn't simply about conducting investigations. It is an organisational risk control function, and it's an opportunity for continuous improvement within your organisation. So let's get started.
So the common types of workplace disputes and complaints. So the types of disputes and complaints, I guess, what is a workplace dispute or complaint? As a starting point, these should be understood broadly. It's important to understand the type of matter you're dealing with because this will often determine the actions you need to take to resolve it. The typical matters that can occur in the workplace context include conduct complaints, such as bullying, harassment, misconduct or inappropriate behaviour, discrimination and protected attribute complaints, so where the complainant allegations relate to a protected attribute under discrimination legislation, such as sex, race, pregnancy, etc. Performance management process complaints, so arising from performance reviews, warnings, feedback or supervision. Interpersonal conflict and relationship breakdown complaints, so that's things like personality clashes, communication breakdowns and loss of trust. Cultural or systemic complaints, they're usually concerns around toxic culture, team dysfunction, lack of accountability, poor leadership or systemic exclusion. And then the last one there is industrial conditions and entitlements disputes, so about pay, classification, rosters, consultation, award or enterprise agreement interpretation, union rights, redundancy or workplace change. And so we're looking at, you may have noticed that the last one I referred to was a dispute rather than a complaint or grievance, which we'll collectively refer to as complaints. And these terms are often used interchangeably in the workplace. So I guess what is the difference, if any? Well, in the workplace context, there is a difference. So a workplace dispute is a disagreement about workplace rights, obligations or entitlements, or the interpretation or application of an industrial instrument such as an award or an agreement. Often involves union employee representatives or a group of employees, and may trigger a formal dispute resolution procedure. And these can also be escalated to the Fair Work Commission for conciliation, mediation or arbitration, as opposed to a workplace complaint, which is generally an expression of dissatisfaction by an employee or a group of employees about a workplace issue that affects them. Usually it's about the employee's experience or their treatment in the workplace, and it's often managed via the employer's grievance procedure or complaints process. And I raise this not just to clarify the difference, but because today's webinar is also looking at workplace investigations, which generally form part of a complaint or grievance. So we'll specifically focus on complaints rather than disputes in the purest sense, and we'll look to potentially addressing those in a separate webinar. I guess the key takeout from this is just that you need to understand the issue because understanding the issue is the first step to reaching a successful resolution. So Rebecca will now discuss the best practice principles for managing complaints.
All right, so best practice principles. Where do we start? As I said, it's more than just about closing out a grievance or following a process to a T. Typically, an organisation will have a policy or procedure which outlines the process by which a complaint is received, recorded, assessed and resolved. And that's often referred to as the complaints management system. Best practice complaint management is the practical mechanism by which an organisation meets its legal duties to prevent harm, respond fairly, protect workers and improve systems. So in that respect, there are a number of legal anchors around a complaints management system. This is especially important for sexual harassment and sex-based harassment and discrimination. Under the Sex Discrimination Act, employers and PCBUs have a positive duty to take reasonable and proportionate measures to eliminate, as far as possible, that conduct. Similarly, under work health and safety legislation, a PCBU owes a duty to ensure the health and safety of workers and others, including their psychological safety. Complaints which involve bullying, harassment, interpersonal conflict, sexual harassment and discrimination, enlivening or are effectively unsafe workplace behaviours that enliven or intersect with those particular duties, and a best practice complaints management process is just one tool that an employer or PCBU has and uses to discharge those duties and to prevent foreseeable harm. Other legal anchors include Fair Work protections, for example, general protections and unfair dismissal protections. A best practice complaints management system actively mitigates against risks in relation to those matters because it ideally provides decision makers with a concrete basis for their decisions and sound and defensible reasons. So there's a number of things to consider there. Whistleblower and protected disclosure obligations are also highly relevant to the best practice complaints management, and the importance of identifying matters that require special handling or treatment is important. So the practical implication of these legal anchors is when a complaint is received, the organisation is, in addition to dealing with substantive complaints, asking itself, what risk does this reveal and what controls are needed now? So best practice principles actively support compliance with those legal and statutory obligations. They inevitably produce a better experience for individuals and organisations. In practice, what that looks like, we've identified on this particular slide a bullet point list of those things. And in terms of accessible reporting pathways, I think this is a fairly commonly misunderstood aspect of a best practice complaint management system. So the Australian Human Rights Commission Positive Duty Framework provides some really useful guidance around reporting and response. As one of its keys, there are 7 standards in its framework. And this is important because reporting is often a barrier to these issues coming to light. And it's not unusual for some complaint processes to start with a gate that says formal reports only in writing. The AHRC Positive Duty Framework says, and obviously based on the Respect at Work report findings and recommendations, is that multiple reporting channels beyond a line manager, but including HR and senior leaders or other escalation pathways, verbal, in writing, formal, non-formal, anonymous or not, really need to be the range of pathways available. So it's the gateway for the issues coming to light and one of the most critical stages. Early triage and risk assessment, effectively, we'll come to that in the next aspect of the discussion, but it's really about understanding that in response to a complaint, work health and safety duties in particular will require an employer or PCBU to actively identify and manage risks to health and safety, which principally in this context arise in a psychosocial hazard and workplace interactions and behaviours that might need to be adjusted or managed. So an initial assessment of the seriousness or the presence and seriousness of those safety risks is important. Procedural fairness we'll talk about a bit more. Terrianne will cover off in investigations, but procedural fairness needs to be afforded and sometimes referred to as organisational justice afforded to all participants, not just complainants and respondents, particularly if a bystander complaint is made and how bystanders and witnesses and other people with relevant information are treated. And we'll come to a short discussion on taking a human-centred approach. Support and wellbeing we'll also discuss shortly when it comes to how that interacts with a person-centred approach. Ultimately, evidence-based decision-making is a fundamental aspect of the process, and some of the decisions we'll discuss really illustrate well the traps and pitfalls for organisations when it comes to making decisions and the importance of a well-run independent investigation in particular for supporting decision making. And I think it can be really disappointing, and some of the cases illustrate this, when decisions are undermined by failure in that aspect of the process. And of course, in terms of particularly a risk management perspective, review and continuous improvement is an important piece of this pathway and an important final step in terms of understanding what control measures, for example, did we have in place, how well did they respond to the identified risk, what didn't work and what can we improve, or what new issue that we hadn't considered previously does this particular complaint identify. So this is effectively a holistic approach to not just the particular incidents and facts and specifics of a complaint, but an organisation sort of level response to complaints built in to your process. I mentioned before that there are common pitfalls and risks, and this slide sets out some of those common traps that organisations can fall into and how these contrast with best practice. Ultimately, the foundational principles for best practice centre on how individuals and participants are treated during the complaint management process. So that brings us to a discussion on a human-centred approach. And the foundational principles here are around ensuring that individuals, whether they are the complainants, respondents, witnesses or bystanders, are treated with dignity, neutrality and respect. And neutral treatment means the employer doesn't prejudge facts before evidence is assessed. Everything needs to be taken on its face and subject to the rigour of whether it be an internal or external investigation. Judgment on what did or didn't happen or what is and isn't possible needs to be reserved. Because workplace complaints often involve or inevitably involve emotional and psychological complexity, where individuals may experience fear about repercussions, distress, about treatment, anger. There could be confusion and a sense of a loss of control and a lot of anxiety about reputation. And that goes both ways, but particularly for respondents who are the subject of serious allegations. And a human-centred approach in that context is not a soft alternative to legal rigour. It's actually a risk control. Providing or demonstrating empathy, clarity and respect will often and in all cases improve the quality of evidence and reduce escalation. In that sense, I think it's also worthwhile bearing in mind that it's possible to support employees and other parties involved in the complaints response process without accepting allegations are proven. And in that respect, what you're doing is taking a consistent approach by following your process, but tailoring how you apply that based on what the emotional or psychological complexity of the particular scenario raises. So consistency is essentially around providing equal respect for parties, clear process standards, And so a complaint management policy, for example, that is available to employees is going to set expectations about what will happen next. And so it's important that those steps and those policies are followed, or where they're deviated from, or where those policies are flexible, that there's some rationale and explanation around any deviation from what might be the expectation. Comparable access to support is important. And so what that means is providing both the person who has made a complaint and the person who might be the subject of a complaint, if it's, for example, interpersonal conflict, with their own sources of support and a fair opportunity to participate in the process. Being human-centred, I liken to being trauma-informed, in the sense that it means understanding that trauma, which will be the experience of the individual and its impact, affect the approach and the appropriate responses to responding to those complaints. So with these human-centred foundational principles in play, employers and organisations responding to complaints will go a long way towards taking an appropriate trauma-informed approach and response. I think ultimately, when it comes to best practice principles, what we're really saying for employers is these are the questions, or for organisations, these are the questions to ask yourself. It goes beyond, do we have a complaints policy? Again, is linked back to those legal anchors and linked back to the broader organisational perspective around not just compliance, but also improving the experience for individuals involved in the workplace. Okay, so we then come to consider what initial triage and decision making is required when a complaint is received. And this is a discussion really not about deciding whether the complaint is true, but deciding what risks it raises or what risks exist, what immediate controls are required, what process is fair, and who should make each decision. So these are early decisions, and this early decision-making phase needs to be structured, documented, and risk-based. As a benchmark, the decision makers are able to explain why they've chosen a particular pathway, why they've imposed or not imposed interim measures, which we'll come to, and how it balanced safety, fairness, confidentiality, and legal obligations. Then that's the standard to be aspiring to when it comes to that initial decision making. So on this slide, we've mapped some of the key decision stages when a complaint is received, and different stages will present different challenges depending on the nature of the allegation and the organisation's capability or capacity in terms of managing that. But one of the common challenges that arise here are at the initial risk assessment stage. And the immediate question to be asked is, are immediate controls required? And that requires an assessment of what the risk to around ongoing harm is, whether there's a risk of retaliation, evidence interference, psychological injury, violence, self-harm, reputational damage, or if there's a regulatory obligation to make a notification, which might depend, for example, on whether there's an injury or whether there's been a breach of rule or standard that might apply in that particular environment. We'll come to what those adjustments might involve, but for example, where there's a risk of retaliation or there's a reporting relationship that imposes a risk of psychological harm or injury to an individual, then the types of interim measures you take might include things like adjusting reporting lines or having people working from home or in distinct parts of an organisation with directions not to make contact with other people as appropriate. The other thing that comes up commonly is the legal and policy classifications, particularly where there's sexual harassment, discrimination, bullying. But other common issues arise if a whistleblower obligation is triggered, or at the very least making that assessment early and identifying early that this complaint does trigger a whistleblower obligation because of the importance of protecting the identity of disclosures in those circumstances. And of course, does an applicable policy require an investigation? The importance of understanding for those who are receiving complaints, the importance of understanding what are our policies in relation to these issues. Does our policy say we will investigate all claims or all complaints that have a particular, that are of a particular nature? Because compliance with your policies really goes to ensuring that the expectations that have been created are met when it comes to what you will do in response to a complaint. And the failure to meet those expectations can become a compounding factor, particularly around distress for complainants. And then, of course, interim measures, what temporary controls are needed. So whether risks that are identified in that initial risk assessment can be controlled through changed reporting lines, roster changes, changing work locations, no contact directions, etc. Whether or not that can be achieved is always going to be fact and context specific. And it's important and sometimes difficult to strike that balance between preserving fairness and mitigating risk, particularly where you haven't prejudged the outcome. And often respondents who are, for example, directed to work from home or perhaps even placed on a paid suspension feel that that's punitive. So it's important to frame those interim measures around an identified risk in particular. And even if it's an identified risk around the possibility of witness interference or perceived influence that an individual might have if they remained in the workplace, and that it's not a pecuniary or a punitive measure, and it doesn't reflect prejudgment of the outcome of complaint, but it is a lawful and reasonable direction because of an identified risk and to manage the work health and safety obligation that is owed to everybody in the workplace. So that's some of the framing around interim measures and how that's sort of conveyed. But clearly here on this slide, we've got a bit of a sliding scale in terms of the seriousness or the impact of the intervention or the interim measure, everything from a no contact direction, which would be appropriate, for example, where there's no specific risk of harm identified, but ongoing contact might create distress, and it's feasible for those individuals not to necessarily have contact with each other, provided it doesn't prevent somebody from accessing support, representation, lawful reporting channels. And it's not unusual sometimes for the direction to an employee to include something like, you can't talk to anyone else at work about this. And so there may be occasions where you identify that an individual might need to be able to access support. There needs to be some flexibility around that. In terms of the other options, like I said, it's a bit of a sliding scale in terms of the more serious the risk identified, the more likely you're going to move towards something like a paid suspension or temporary, duties where they're reassigned effectively to undertake some other work. And the decision making around that requires, particularly if you're moving to paid suspension or variations of duties or location changes, requires some consideration around some of the legal bases on which you might do that. Principally, you'll be acting under a work health and safety duty and frame that as a control measure around an identified risk. But consideration of things like the contractual basis for the direction would need to be considered. More often than not, when we are advising clients about contracts, particularly for high income or senior level employees, an agreement to an explicit or express term dealing with the right or ability of the employer to direct a paid suspension is appropriate, and there would be sort of appropriate wording around the parameters of that ability to give that direction. So here we have a framework, series of questions that assist with that decision making around understanding what's motivating the decision to suspend as a control measure, exploring alternative options, understanding the lawful basis of a direction for suspension would ideally be found in the employment contract, but there may otherwise be a policy or industrial instrument that deals with the ability to do that, particularly in the public sector. Paid suspension, more often than not, is going to be the lowest risk approach. Suspending without pay on the basis of alleged misconduct can be very difficult to establish a lawful basis for and creates other risks. And I think that sometimes overlooked is the question of how long is this going to last? And it ties in a bit with what Terrianne will discuss in relation to investigations being undertaken in a timely way. But you want to ensure that the suspension is framed in such a way that it's tied to the outcome of an investigation and then that the investigation is promptly progressed. Got some other considerations here. One of the other early triage and early decision-making pieces is around the appointment of an external investigator. And so we've got just a couple of prompts here about the circumstances in which it's going to be appropriate to do that. You know, in some respects, it becomes a decision that's not difficult to make. Ultimately, independence, I think, is a driving feature around this decision-making. So it's not necessarily about whether, look, this is a difficult or tricky investigation, but is an external process going to improve confidence in the outcome and reduce perceived bias? The complexity of the investigation, though, I think can warrant the decision to appoint the external investigator because of resource-intensive nature of more complex and sensitive investigations, and the organisation may want to preserve its capacity internally for business as usual and other things. Okay, so I'll leave this slide here for you to reflect on later. We'll keep moving just on that note of moving in a timely and prompt way. So I'll move to Terrianne, who will talk to you a little bit more about best practice processes in workplace investigations.
Okay. So thanks, Rebecca. First of all, I'll just quickly go through the foundational principles associated with conducting workplace investigations. A defensible workplace investigation is governed by these cross-cutting principles that apply throughout the process. These principles, they're not discrete boxes to be ticked at the end. They have to inform every aspect of the process from complaint intake right through to decision making. So external scrutiny generally focuses on whether the overall process was conducted in accordance with these principles. And those principles are, you know, as you can see there, procedural fairness, natural justice, applying those principles to the investigation, impartiality, and independence. So as to what Rebecca was indicating earlier around, you know, the decision around who should investigate, timeliness and proportionality. So how, you know, timely was the investigation conducted? How was it dealt with? Was the outcome proportional to what was said to have occurred? Confidentiality and information control, very important throughout the process, because, you know, that will lead to other issues if you don't retain the confidentiality of the information that you have. Evidence-based findings are very important. I'll talk about that in a little bit. And talking about the balance of probabilities as the standard of proof. So looking then to the investigation itself, so it generally will take 3 stages. The first one is the preparation stage. So a robust investigation begins with a clearly defined scope. So you want to scope the investigation and prepare your terms of reference. Formal terms of reference are especially important in matters that involve serious allegations, senior managers, or that are likely to be scrutinised by a tribunal, regulator or court. The terms of reference will define the investigator's appointment and their powers and limitations, the issues and allegations to be investigated, the time frame for the investigation, the persons or workplace areas that are in scope, and the applicable standards to be applied, such as your code of conduct or workplace policies, the reporting requirements that are to be delivered by the investigator, and whether recommendations are permitted. So if recommendations are outside the scope, the investigator should not include those. They create accountability and procedural discipline. They also protect fairness by ensuring that there is a shared understanding of what is being investigated, and that the investigator doesn't drift into unrelated matters without authority, because that can often happen, particularly where you have witnesses who might, pull a rabbit out of a hat and, you end up in left field somewhere. The terms of reference will continue to focus you on what you need to be investigating. The next thing is the plan and design of the investigation methodology. So the investigation plan should identify each allegation or issue to be investigated, the elements that are requiring proof, the relevant standards that they'll be measured against, likely witnesses or witnesses that have been identified already, documents and records that are required to be reviewed, interview sequencing, evidence preservation steps, interim risk control. So the things that Rebecca was talking about earlier in the decision making, that will be considered in the planning stage as well. Communication protocols, which are very important to establish at the outset, so that you know who's going to be communicating to who and when and what they're communicating, etc. Your timeframes and any milestones that need to be achieved throughout the process. Confidentiality arrangements, any support arrangements that you're putting in place for the parties involved, and the reporting requirements. So that's all included in the plan that you need to establish. And this can be done in any sort of setting. It doesn't have to be every single little piece of everything to the letter with long documents, etc. But those are all the things that you need to consider when you're planning an investigation, even if it's a less formal one. Okay, so, planning reduces ad hoc decision making and helps ensure that evidence is collected in a logical order. So evidence should be preserved early if you're doing that, CCTV, emails, text messages, data logs, etc. And you may need coordination with other departments such as IT or HR or records management. Sequencing, that matters. The respondent should generally not be interviewed before the allegations are sufficiently particularised. So you may need to interview some witnesses prior to interviewing the respondent so that you can establish the allegations to the correct standard that you need. And the organisation needs to have a defensible process, so it should include realistic but prompt timeframes. So where complexity requires extensions, those extensions should be explained and documented. Unexplained delays are significantly more damaging than justified timeline adjustments. Now, then the next thing is drafting the formal allegations. So the allegations letter is often the practical foundation of procedural fairness. So drafting the formal allegations can be one of the most legally sensitive stages in the process. The allegations must be sufficiently particularised to allow a meaningful response, but not framed in a way that assumes guilt. So they crystallise the conduct in issue and notify the respondent of their case to be answered. They should identify the alleged conduct, not merely recite labels. So, for example, bullying is a characterisation, as opposed to on such and such a date, you allegedly said words to the effect of such and such to X person in whatever context that may have been. So that's a factual way of stating that allegation of bullying. So because the respondent must understand what they are said to have done and why it matters. You should also avoid language such as, you deliberately bullied, unless intent is itself is properly particularised. You lied, unless this dishonesty is expressly in issue and supported by particulars. You harassed without identifying the actual conduct. You act disgracefully. without any facts, you committed serious misconduct before findings are made. So it needs to be neutral, factual, and non-prejudicial. And then each allegation or group of allegations should identify the potentially relevant standards. So your code of conduct, workplace health and safety policy, lawful direction, contract term, those types of things. The allegation should distinguish between the underlying factual question and the evaluative question of whether established facts amount to misconduct or some sort of breach. The allegations letter should usually include the investigator's identity and role, the investigation scope, what the allegations are with the relevant particulars, any documents or summaries of adverse material that exist, the interview dates and arrangements, support person arrangements, confidentiality expectations and non-victimisation expectations, what response options are available to them, the time frame for a response and a contact point for process questions. Supporting material can be redacted or summarised where necessary, but not to the point that the respondent cannot understand and answer the substance of the case. We look at the next stage, which is conducting the investigation itself. So the documentary evidence often provides the most reliable foundation for findings, especially where witness recollections differ from each other. So contemporaneous records are particularly valuable. Evidence collection should be systematic and balanced, and the investigator should actively consider material that supports, contradicts, or contextualises the complaint. There are many types of relevant material that can be gathered, but relevance depends on the allegations. Over-collection may compromise privacy and distract from the issues at hand. Particularly contemporaneous records can assist where they were created at or near the time of the events. They may be less affected by memory decay or later reconstruction. However, contemporaneous records are not automatically accurate. So you need to consider who created the record, when and why it was created, whether it's complete, whether it records direct observation or hearsay, whether it may be self-serving, whether metadata supports its authenticity, and whether other evidence is consistent with it. A fair investigation does not collect only evidence supporting the complaint. The investigator should also consider material that may assist the respondent or contradict the complaint, which is called exculpatory material. The next thing is identifying and managing witnesses. So witness strategy affects both fairness and efficiency. Investigators should distinguish between direct, corroborative, contextual and peripheral witnesses. Witness management should minimise contamination of the information while allowing participants to provide full and reliable accounts. An investigator is not necessarily required to interview every nominated witness either. Witnesses should be identified by relevance, not by status or popularity, and priority should be generally given to those witnesses who were direct eyewitnesses or persons who heard relevant conversations. Other witnesses can also be helpful in establishing timelines or corroborating parts of the evidence of either the complainant or the respondent. And to the point of, the treatment of parties. So some witnesses may require support because of trauma, disability, cultural factors, power imbalance, etc. So support arrangements can improve evidence quality and process integrity, provided the support person does not coach evidence or interfere with questioning. In workplace health and safety contexts, witness welfare is also part of the psychosocial risk management. Interviews are central evidence gathering tools, so interview quality often determines whether findings are persuasive. Workplace investigation interviews are not adversarial cross-examinations, so you're not in a cop show trying to coerce a confession from someone. They're structured opportunities to obtain, clarify and test evidence.
Sorry to interrupt you. We've just got a question. Can I throw that in? Because I think now's a good opportunity. You just talked about interviews. And the question from Lydia, thanks for sending that across, is what approach would you take to naming individual allegations and providing witness statements to those who have participated in an interview?
So naming, that is an interesting concept because it does depend on a number of factors. Generally, I guess the principles are in favour of naming the person who has given witness evidence or who is the complainant, mainly from the point of view of the respondent being able to respond fully to the allegations. So it may be that the respondent is unable to provide a full response to any particular allegation if they're not aware of who has actually made the allegation or who the witness may have been in that scenario. So in those instances, it can be more about managing expectations of complainants or witnesses and letting them know that there are protections in place for them if there is any, retribution at a later date, because the standard is quite high. However, if there is an imminent danger of physical safety of any of the witnesses or complainants in relation to having their name given, this can be exceptional circumstances where you may not necessarily name the person, but you do need to consider that when you are evaluating the evidence, given that the respondent was not able to respond to the full information. So there isn't one size fits all in that. And Rebecca, I don't know if you have anything further to add to that in particular.
Yeah, no, I think they're great observations, Terrianne. Thanks for sharing that. And again, it just demonstrates how being guided by those foundational principles sets you up for answering some of those tricky or dealing with some of those tricky issues as they arise. Okay, so let's keep going then.
So I guess in terms of then the respondent interview, this is always a critical procedural fairness stage. The respondent should be given a fair opportunity to address each allegation, and that goes back to the point that I was just making. So they need to have, the allegation put to them clearly, allow the respondent to answer fully. They need to be able to test documents and witness accounts, ask them for explanations, ask whether any witnesses or documents should be considered as well, explore the context, avoid assuming guilt, because remember, the respondent does not bear the onus of proving their innocence. The investigator must assess the evidence as a whole. So that can often be a trap for people. A good interview usually begins with open questions like, tell me what happened, what did you see or hear, what happened next, etc. And then the investigator might then move to focus questions to test detail, chronology, consistency, plausibility, documents, that sort of thing. Lastly, timeliness is a legal, evidentiary and safety issue, as was discussed earlier by Rebecca. So, making sure that you go through a managed, disciplined and proportionate time frame. Timely does not mean rushed though. So making sure that you apply appropriate time frames to everything. So then the last stage of it is obviously analysis of the evidence and reporting. So when analysing witness evidence, credibility assessment must be disciplined and evidence-based. It should not depend on intuition, demeanour, confidence, eye contact, emotional presentation or social status. The investigator should assess credibility and reliability by reference to objective and logical indicators. So I guess in terms of then looking through how you would analyse and report, so you need to look at the witness and other evidence, you need to reach your findings, evaluate your policy breach and misconduct and other issues. Now, making sure that you keep the findings separate from the evaluation of the potential breach or misconduct. And then you need to prepare your investigation report with all of that information in there. So for timeliness, I'm going to move through the next part of that. We do have information there on common investigation failures and how to avoid them. That will be included in the slide pack that you get afterwards. But suffice to say that there are a few things that can derail a good investigation once it's scrutinised by third parties. So just be aware of those things and make sure that you take actions to avoid them. So if an investigation can't withstand scrutiny, it can't support a good decision. And on that, I will then transfer to Rebecca for the next section.
Thanks, Terrianne. And look, like we do most of the time when we run these webinars, is we've totally attempted to overachieve. We've got more content than we can get through in an hour. But what we'll do is wrap up the discussion. And this next section deals with some case studies that illustrate both what can go wrong when things aren't done well, and some examples of when investigations, when they are done well. So I'll mention just a couple, but I think one of the things that we take, I guess, some takeaways from these cases are how disappointing it can be when a process undermines what would otherwise be kind of like the right decision. In this particular case here, the fact that there were many complaints was relied on by the employer ultimately in the decision making for a dismissal, whereas the Fair Work Commission's criticism of the investigation and decision making was really around saying, well, it's not enough just to have lots of complaints if the evidence isn't very good. And so in that case, in unfair dismissal, there was no valid reason for dismissal because the underlying conduct couldn't be proven, essentially. In other cases, like this one here, you've got a situation where there were procedural deficiencies in the investigation, but the underlying conduct did occur. So in this case, the sexual harassment was proven and reinstatement was not appropriate, but the dismissal was unfair because of procedural deficiencies and there was compensation ordered. I think the important thing to bear in mind too, when you look at these cases, these are all in the unfair dismissal, or primarily in the unfair dismissal jurisdiction, except for one. And this is where employees are seeking reinstatement. So in the context of someone who you've assessed as behaving so badly that they're out. So the stakes can be high, despite the fact that compensation is limited in the unfair dismissal jurisdiction. The stakes are high when it comes to the reinstatement aspect of those applications. One that isn't unfair dismissal related is Alicia and Vision Australia, and many in the HR and employment relations space will be familiar with this case because it was a significant case in 2024, and it ultimately identified that the risk of the psychological or psychiatric injury arising from that poorly handled complaint is a real risk. This case is something of an outlier in the sense that it turned on whether there was a contractually enforceable obligation around the incorporation of policies into an employment contract. That's not going to be fairly common going forward because most organisations have up-to-date contracts which clearly deal with incorporation. It's a fairly well settled sort of principle now, but this case deals with an older contract wording. So contract claims may not necessarily be flooding through the door in response to this, but the notion of workplace injury certainly remains squarely in the piece here. So there's a handful of cases there that were given sort of short shrift by the Fair Work Commission. And then there are some cases where the investigation supported the decision making and the dismissal there was a valid reason and it was not harsh, unjust or unreasonable.
Sorry to interrupt. I actually have a question from Ashley, who's asked, does IRiQ have a template with guidelines for the investigation report?
Hi, Ashley. How are you going? Great to see you online. What we do have is a checklist, and I think that it's going to be bundled in with the presentation materials that are distributed. And I think that's a useful tool externally because it means that you're going to hit all of the right boxes when it comes to the content of your investigation report, and it guides the investigation itself.
I've actually just in the Q&A answered the rest of Lydia's question because I realised I only covered off on the first half of it. She also asked about providing witness statements, so I've just answered that in the last part of there as well.
Yeah, and just to digress on that topic of providing people with statements, I think you've always got to analyse the risk of information not being kept securely, and so then you've got witness statements floating around the organisation.
And I think we may have one more question.
That one from Amy.
Amy, yes.
Yep. What is the advice when you know the witnesses are lying, all saying that the allegations occurred to benefit their relationship with the person? Witnesses are lying to protect their relationship with their manager, who the allegations are against. Well, look, I think these are the kind of really tricky issues that often will warrant an external investigation for the purpose of that independence and rigour around testing witnesses that sometimes internal investigators can't sort of manage because of relationships. But it also goes to, I think, that question about what interim measures need to be in place, because if the manager who has a good relationship with their team has a degree of influence, the example you've given is that he or she, I should say, have a team of people who might be prepared to overlook bad behaviour and conceal it. Removing them can really assist to break down that level of influence, and you can sometimes get to the heart of things. But a finding by an investigator that a group of witnesses who corroborate each other's evidence are together fabricating that is a very big move. And I think you'd need to be able to point to some reasons why and some facts around why. It would need to go beyond sort of a suspicion. And, you know, I suppose it depends on the circumstances, but an independent investigator can bring that degree of independence where they can challenge witnesses around that, to, you know, whether it's put to them that this is a version of events that's been constructed, and the reason that's apparent is because they're all saying verbatim, for example. It's the same thing. But look, that's a really good illustration of how complex some of these issues can be, because they centre around human relationships. And humans sometimes are strange creatures.
Yeah. You know, there's a line between witness corroboration versus, you know, collusion, for example, and understanding the difference and being able to delve into, I guess, gather that additional cogent evidence to prove really that there was collusion, as opposed to just corroborating statements. You know?
Yeah, that's a good point. And I think if you wanted to just pick one case that you looked at, it would be this one of Warren Power and Lyndon's, because that's one where the investigation actually got some attention and some very positive reviews from the Commission, essentially. And if you've ever done an investigation that subsequently, you know, informed a dismissal decision and then been the subject of review by the Commission, this is the kind of reflection that you're looking for in terms of gold stars all round. Okay, and there's another case that's quite useful around outside of work conduct and the connection to employment, but also how the investigation and complaint process played into what was ultimately a finding that the conduct did occur and there was a valid reason for dismissal. So I've rushed through those cases, but I do recommend you pick a couple just to take a look at. The citations are there. And what we learned from the cases is that it's not just a question of whether the employer or organisation investigating or responding to the complaint came to the right conclusion or got the right answer, because the cases show that sometimes you get the right answer, but because of how you got there, you get pinged. So it's really about whether the employer can prove that it reached its answer through a fair, evidence-based and defensible process. I'll leave that there for the takeaway. And that brings us to the end of today's webinar. I think we did reasonably well, Terrianne, to only just tick over 10 minutes over time. Yeah. And like I said, we'll be providing the materials to those who are registered. We've answered some questions as we've gone, but otherwise you'll also find some information in the pack about how to stay in touch with us. And a really good way to do that is to subscribe to our newsletter, where you'll get information about our next webinar and articles and checklists and other things that we provide to provide some support and assistance in what is an increasingly complex aspect of law and practice in industrial relations and employment relations. All right, well, we're going to sign off. Thanks again, Terrianne.
Thank you. Thanks everyone for joining us.
See ya.
Thank you, bye.